The National Security Advisor of Nigeria, at a time that terrorism is ravaging our country, that people are being killed in their hundreds, has now gone on record to say, yes, I was careless enough, I was reckless enough, I am so incompetent that the NSA, my own phone, has been wiretapped.
Now, a number of questions raised in that regard. The first is, Nasir Rufai was quoting somebody else, a third party. What he said, did he say it under caution? He was on television, just talking on television. If that was an extrajudicial admission, then, of course, it was not under caution. So it will be problematic in law, as Inibe Effiong has argued correctly.
There is a current legal case filed in court against Nasir El-Rufai relating to alleged phone call interception or tapping comments he made during a live interview on Arise TV. If you're not be following the case, I'm going to be giving you the basis of the case. But firstly, if you're just seeing my channel, I beg you help me to subscribe to this channel, like, comment to this video, and help us to share so that YouTube will feel recommend them. Now, let me give you the basics of the case. The federal government filed a 3-count criminal charge against El-Rufai at the Federal High Court, Abuja. The case file number is what you are currently seeing on the screen right now. It stems from remark El-Rufai made during a 13th February 2026 interview on Arise TV's Prime Time, where he said the phone of the National Security Advisor NSA was tapped and that he had the NSA's call. The 3-count charge, count 1, that El-Rufai admitted publicly to unlawfully intercepting the NSA's phone communication in violation of Section 12 subsection 1 of the Cybercrime Prohibition Prevention etc. Amendment Act 2024. Count 2, that he stated he knew individuals responsible for the unlawful interception but failed to report them to relevant security agencies, contrary to Section 27B of the Cybercrime Act. Count 3, that El-Rufai and others used technical means in a way that compromised public safety and national security by unlawfully intercepting communications, contrary to Section 131, subsection 2 of the Nigerian Communication Act 2003. But here are what some legal practitioners are saying and some critics. They are of the opinion that government should first confirm if the phone was truly tapped, that in matters involving national security, alleged interception of classified communication, public accusation, the proper sequence in most democracies is 1. Internal security investigation, 2. Intelligence verification, 3. Assessment of breach level, 4. Then legal or disciplinary action. So this is what some people are saying. But firstly, I want you to watch this video.
Joining us on this segment is constitutional lawyer and human rights activist, Mr. Inibehe Effiong. He joins us right here in our Lagos studio. Mr. Effiong, good morning.
Thank you. Good
and
morning.
Welcome to the program.
Good to be with you. Always a pleasure. Thank
yes,
you.
indeed. Now, I took time to listen to him yet again, and here's what he said in that interview. He said, because that I know, but the government does it all the time. They listen to our calls all the time without a court order. Someone tapped his phone and told us that he gave the order. That's the order for his arrest. That's the admission of the former Kaduna State governor, that he tapped the phone conversation of the National Security Advisor. Now, talk to us about how this can stand as evidence in a court of law, and if this will go anywhere in the charge that the federal government has now laid before the former Kaduna State governor.
Thank you. Let me start by saying, without equivocation, that wiretapping or tapping the phone conversation of any person ordinarily is a matter of grave concern. It is not only one that predicates on possible breach of the right to privacy as guaranteed under Section 37 of the Constitution, which states that the privacy of citizens, including their telephone conversations and telegraphic communications, is hereby guaranteed and protected. So the telephone conversation of every person is constitutionally protected, and there is no allowance for invasion of that privacy except in the manner permissible by law, namely where, for example, there is an order of court, or where it is done maybe in furtherance of national security, provided certain constitutional and legal safeguards are met. Now, I have watched, I have reviewed, I have evaluated the statements made by former governor of Kaduna State that has now become a subject of legal contestation. What he said, is it excusable? No. Should it be encouraged? Certainly not. But has he committed a crime? There's a constitutional right to presumption of innocence. I'm not going to pass judgment on the merit or otherwise of the charge that they. The National Security Advisor of Nigeria, at a time that terrorism is ravaging our country, that people are being killed in their hundreds, has now gone on record to say, yes, I was careless enough, I was reckless enough, I am so incompetent that the NSA, my own phone, has been wiretapped. But it appears that is what he's saying by the charge. Because they must take a position, definite position, whether his phone was wiretapped or not. If it was wiretapped, it speaks to his competence. If it was not wiretapped, what is the basis of the charge? They should resolve that first. I have started by saying that what Erufai said was unacceptable.
Sorry for cutting in. So who has to prove what? Let's take it in steps. That is the first charge, the second, or either the first count or the second count now. Who has to prove what? Is it the NSA or the DSS in this sense, or SSS, whatever name they call it, that will have to show that indeed Nasser El-Rufai, through his whoever proxy, actually did wiretap, or Nasser El-Rufai has to show that he actually did? You get my point?
El-Rufai doesn't have to show anything. I'm willing to take anybody on this with all sense of humility. I think every lawyer should agree to that point. He's not obligated to say anything. I'm not his fan, I'm not his admirer. I remember when he introduced the religious regulation bill in Kaduna State, and I wrote this article that went viral at the time. El-Rufai personally sends what I would describe as very unnecessary email to me. We were exchanging communication at the time. I was very antagonistic that why should I have an opinion about what is done in Kaduna State. So I don't see him as somebody who is tolerant of dissent. So I'm not speaking here holding brief for El-Rufai. I am saying that this government has shown seriousness in this matter. It doesn't have to say anything as far as this case is concerned. Because when you look at the charge, have they even told us the instruments that he used for the wiretap? Have they told us which of the phone of the NSA that was wiretapped? These are things they must disclose in the charge. Let me be heard on this point, which is part of the reason why I said FSF has no business prosecuting. They use the word cohorts, and your cohorts that is so unnecessary to put it in a very mild language. Why will you use that kind of language in a charge in his cohorts? Cohorts. So they quickly went to file this. If the SSS was to undertake a serious investigation, you can look at it. When they concluded, they should have forwarded the file to the Ministry of Justice. The Ministry of Justice would have reviewed it and decided and took a decision whether to prosecute or not. I am saying that based on what they have disclosed to us, I'm not sure that this is something that should go to court. And if it had to go to court, it is the Attorney General of the Federation, or at best, maybe the police that should have filed this charge. This first is supposed to be an intelligence gathering agency. Because we are so used to lawlessness in this country, because we are so used to doing things the wrong way. So that is why in Nigeria today, the State Security Service is being deployed for things that are outside their mandates. They basically do all sort of things.
So, regardless of the technical inadequacies of the filing of the charge on the part of the government, the federal government, and even if El-Rufai pleads the fifth in this case by not self-incriminating himself, the government, on the other hand, also has admitted that indeed, by this charge, that the NSA's phone was wiretapped. Does it then mean that because of the technical inadequacies, the court will not find El-Rufai guilty, or because there has been an admission to a crime on national television, there is indeed a case before the court that can sail through?
Again, being cautionary, I cannot speak to his guilt. The court will make that determination. What I can tell you, and what I can tell you very strongly, is that the burden of proof rests entirely on the prosecution. It never shifts. Even if they want to argue evidential burden, I don't see how that will inure in their favor here. They will have to prove his guilt. El-Rufai, again, is not obligated to say anything.
Safe, which compromise public safety, national security, and instilling reasonable apprehension of insecurity among Nigerians by unlawfully intercepting the phone conversation of the National Security Advisor, excuse me, Nuhu Ribadu, to which you admitted during an interview on the 13th of February 2026 on a Rise TV station primetime program in Abuja, and thereby committed the offense contrary to and punishable under this.
What is the technical equipment that was used?
I read the charge because I wanted you to see
the charge must have particulars.
Yes, I read the charge because I wanted you to see the premise of arrival.
I've seen it.
The premise of arrival.
I'm saying that the charge must disclose particulars.
I think largely you spoke to that earlier.
What is the name of the equipment? When was it acquired? Where is it kept? Who has access to that equipment this morning? These are questions that a serious investigative agency ought to answer. But what is their attitude to it? Somebody woke up in the morning, had a bad dream, rushed to court to file a charge, did not bother to speak to the person you want to prosecute. I am telling Nigerians, and I want to be quoted on this, that the federal government of Nigeria has no interest in prosecuting Nasir El-Rufai on this issue.
Now, a number of questions raised in that regard. The first is, Nasir El-Rufai was quoting somebody else, a third party. What he said, did he say it under caution? He was on television, just talking on television. If that was an extrajudicial admission, then of course it was not under caution. So it will be problematic in law, as Enibe Effiong has argued correctly. The second point is that what is known under the National Security Agencies Act to Nigeria is the State Security Services, not the Department of State Services. So the question in law will be, can a non-existent entity prosecute? The third issue is that the DSS or the SSS does not have prosecutorial powers. That should have been done through the office of the Attorney General of the Federation. Number 4 is that there are national security dimensions to the case. Now, in terms of national security, the issue will be, how has the statement breached national security? So there is this intersection between politics and law. And that was why I was saying the other day that national security in Nigeria should not be reduced to the level of politics or conflict between two former friends who are now enemies, as it were. And so there's also that personal leg to it. But the overriding point with regard to national security is that the state, the Nigerian state, is trying to prove a point, which is important, that no individual is above the law. And 2, no individual can overwhelm the Nigerian state.